Rebecca Gonzalez, National Association of Social Workers, California chapter, also in support.
Okay, others in support can do Me Too's, I think.
I'm Kim Lewis, representing the California Coalition for Youth, which represents runaway and homeless youth providers, as well as AspiraNet, one of the largest foster care providers in the state, in support of this bill for our most vulnerable youth.
Jesse Stout, Legal Services for Prisoners with Children, co-sponsor of related legislation. This committee has passed SB 504 in strong support of AB 666.
Janice Stillman with Legal Services for Prisoners with Children in support.
Micah Doctoroff, ACLU of California, in support.
Khalif Assagai, California Public Defenders Association. We were the sponsor of the original bill, and we appreciate Asylum Stone's effort to improve the process.
Dennis Garcia on behalf of the California Attorneys for Criminal Justice, in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California, in support.
Thank you. Others in support? Speakers in opposition to the bill?
Thank you, Madam Chair and members. Sean Hoffman with the California District Attorneys Association in opposition to Assembly Bill 666. The purpose of delinquency jurisdiction is that the minors receive care, treatment, and guidance that is consistent with their best interests, holds them accountable for their behavior, and is appropriate for their circumstances. As participants in the juvenile justice system, we as prosecutors have an obligation to consider the protection of the public and the best interests of the minor and hold ourselves accountable for the outcomes in the system. Without the ability to review the records that have been sealed, we can't meet this obligation. The analysis notes that the sponsor's argument is, the fundamental policy reform underlying the bill is that we want to make sure that nobody's being unduly burdened in their attempt to get a job, go to college, join the military. We don't disagree with that. In fact, I think that the intent of AB 666, as was the intent of SB 1038 by Senator Leno last year, is noble, and we don't want to unduly burden individuals who make mistakes and, had delinquency contacts as juveniles. However, keeping that information from participants in the juvenile justice system doesn't further those interests and in fact frustrates the entire purpose of delinquency jurisdiction. When a minor recidivates, which may be in a very, relatively few instances, as we heard from the supporters, neither the prosecutor nor the court will have access to critical information about the minor's prior contacts with the system. So in order to ensure that we can make decisions regarding treatment, placements, and programs that are appropriate and in the best interests of the juvenile, we need access to those records beyond the extremely limited purposes for which this bill provides. We think it's possible to prevent a juvenile record from negatively impacting someone's ability to get a job, go to college, join the military, without further limiting that access to those records by the juvenile justice system participants who are charged with acting in the best interest of the minor. We heard from one of the sponsors that there are other ways for us to go about getting this information. We can go to probation, we can go to CPS. If they're admitting that we can get the information in other ways, why is it problematic for us to be able to go directly to the information instead of relying on some kind of bizarre game of telephone to get the information? We think AB 666 is an overly broad approach that will have a detrimental effect on outcomes in the juvenile justice system, and ask for a no vote.
Madam Chair, members, Aaron McGuire on behalf of the California State Sheriff's Association, echoing the comments of the District Attorneys Association as well. We're also concerned just about the practical ability of destroying these records upon court order, as well as subsequent field contacts that our officers may have with juveniles and now may no longer have information about what they might have been had those contacts with. We look at it as a potential officer safety issue, and for those reasons we're opposed. Thank you.
Good morning, Madam Chair and committee members. My name is Nancy Smith. I am the Supervising Deputy District Attorney of the Juvenile Division in the Sacramento County District Attorney's Office. We fully support the policy behind the idea of wiping the slate clean for juveniles who have rehabilitated, who are moving forward to become productive members of the community, to seek gainful employment, to enter the military if they so choose, and so forth. So again, first and foremost, we do support that policy. However, I am in court every day with youth here in this community in juvenile delinquency court. And the reality is that when juveniles do rehabilitate and do have their records sealed, we often do see them come back before us on new petitions in delinquency court and dependency court. Those are the realities of some of these youth. And when the petitions are sealed and we do not have access to them as Assembly Bill 666 proposes. Not only are the juvenile records sealed that are in the custody of the juvenile court, this bill proposes that the records in all public agencies are sealed. So the realities are we're talking about crime reports being sealed, probation reports, district attorney files, child welfare records. That means CPS reports being sealed, dependency courts files being sealed. Those are gone. We don't see them. We are blinded to all of those records. So if a young man or a young child comes before our court on a fresh petition and all of those records are sealed, ladies and gentlemen, as a district attorney, I have a fresh petition before me and I know nothing about this child's history whatsoever and I have no legal access to it. Under Welfare and Institutions Code Section 202, the mandate by the legislature for me as a prosecutor and for all juvenile justice partners and for the partners in juvenile dependency court is that I am mandated to rehabilitate a youth to find treatment, rehabilitation, and meet their needs as a child in juvenile court, to find all the needs to bring them back as a successful member of the community and to get them and prevent them from going into adult court. How can I do that if I am blinded and know nothing about their history? I don't know anything about their family background, school background, delinquent history. I don't know if they're a commercially sexually exploited child. I don't know anything about their mental health history. I don't know if they've been abused or not. How can I help them, assist them? I can't. I'm blinded to it. I have no access. And when someone in support says I can seek that through a probation file or through a CPS file, that's absolutely not true under Assembly Bill 666 because the language says all records of public agencies are sealed. That includes probation. That includes child welfare. In addition, Proposition 21 that was passed 15 years ago says, put in place several procedures. One is deferred entry of judgment under 790 of the Welfare and Institutions Code section. It also put into place a procedure for fitness hearings in juvenile court under Welfare and Institutions Code section 707. Under those two procedures in juvenile court, prosecutors and juvenile justice partners must go through very careful assessment factors for youth who come through the court. These are very serious matters for children in our juvenile court system. Senators, we are making very critical decisions for youth at risk in this community and others across the state. Proposition 21st was passed. It was the will of the voters. Under AB 666, if these records are sealed and there is a youth who comes back before the court on a fresh petition, we are not able to do a proper assessment for deferred entry of judgment suitability, not eligibility. AB 666 talks about eligibility, but it does not address suitability. So we are unable to follow what the voters passed under Proposition 21, under the language in AB 666. And we are not able to do a proper assessment that was passed in Proposition 21 under Welfare and Institutions Code section fitness hearing assessments under 707A and C. If AB 666 is passed, our hands are tied. These are decisions that affect whether a child will be in juvenile court or passed on to adult court and prosecuted as an adult. These are serious decisions in a child's lives, critical decisions in their lives. 666 will not allow us to do our jobs. And in order to change what the voters put into place under Proposition 21, it requires a 2/3 vote of the people. And 666 is attempting to change that, and that's a real problem. I can give you another example if you would allow me, briefly. Madam Chair.
No, this is an important topic, and we're going to hear it.
Thank you. I really
I'm-
appreciate it.
Thank you.
I want to give one quick example that affects dependency, child dependency, because I've talked a lot about delinquency. Let's use the example of a child who has been perhaps sexually abused. Okay. We see a lot of children, I can't tell you the number of cases in my unit, where children who have been sexually abused, sadly, then turn to sexually abuse other children. It's so tragic. They may also become commercially sexually exploited children. They've been exposed and now they're being trafficked. The numbers are unreal. We have created a special court in our county for commercially sexually exploited children. We're doing critical work in our courthouse to help these children. We have a special court for them. If their records are sealed, and all of the multiple agencies across the board, all of their records are sealed, as AB 666 suggests, and they come back before us, or in the dependency side, and we have no knowledge or no access to these records, these children on the welfare side can be placed into homes, into foster care homes, into group homes, and no one would know what their history was. No one would know that they were deeply sexually abused as children. No one would know that they may have been adjudicated on, for instance, felony lewd act on a child, felony committing a 220, assault with intent to commit rape. Child welfare can't look into their file because it's been sealed under AB 666. So they might be placing that child into the home with other children, and those other children may be exposed to dangers. They may be placing that child in a group home with other kids and not knowingly
Okay,
expose
thank
those
you.
children
Now,
to danger.
I think we get the idea.
Thank you.
Your goal is to help the children.
We really are, and we urge a vote of no. Thank you.
Thank you. I would think it would be appropriate to have a response from the author.
Oh, would you
of
like
the
a response
bill.
right now?
Well, serious issues have been raised. To me, the particular issue that has been raised is the desire of district attorneys and sheriffs to help children and therefore to have access to the records for therapeutic purposes.
Indeed. And let me respond to that. Let me read from the bill, okay? It says, "The court shall order sealed all records pertaining to that dismissed petition in the custody of the juvenile court and in the custody of law enforcement agencies, the probation department, and any other public agency having records pertaining to the case." What's been suggested is all of the records in CPS, in all other aspects of that child's life, are being sealed. That is not the case. We're also not sealing the records of juveniles who've committed serious or violent offenses. These are non-serious, non-violent offenses. These are the records of the case. And to presume, and again, read the bill, to presume that all other court or all other records in all the other aspects of what that child has gone through, CPS or pendency courts, get sealed because of this. This is specific to the case at hand, that child was convicted of the crime that child was convicted of. The promise, and this has been the promise for 50 years, the promise to that child is that that offense will be deemed not to have happened. So if we don't seal the records with respect to that case, then we cannot fulfill that promise. We're not actually, in this bill, creating the underlying sealing of the records. We're closing some loopholes, clarifying some provisions in the law about how that sealing happens. And now a lot of the opposition's asking for enhanced access under this bill. And to me, that doesn't make sense. The underlying objections to this bill that you're hearing are objections to the existing law about what gets sealed, when it gets sealed, and how that happens. That's not what AB 666 is about.
Okay, I'd like to hear
Okay,
from
good.
the,
And I
from
hope
the
Mr.
sponsors
Bowie
as
will have a
well.
comment. I'll be
And
brief,
just
'cause
to
this is-
point out that I do notice on page 4 of the bill that this bill does not, in fact, deal with 707 cases, which are the more serious cases.
Yes, and on that point, the assertion that the fitness hearings would proceed blindly doesn't make a lot of sense to me, because those fitness hearings involve the very charges for which sealing is not available. So that's one point. I find the prosecution's statement that they are completely handcuffed in a case because of AB 666 to be overblown for a variety of reasons, some of which the author has just recounted. They have investigational resources, I hope, that will allow them to uncover the information they need to proceed without going into the sealed record on a basis that could threaten the purpose of AB 666 and 1038, which is, again, to protect minors against leaks, disclosures, and misuses of the record that get in their way when they go to apply for jobs, join the military, and so on. Current law, as the author has noted, under 781 does not allow this access. So in some sense, the prosecution is using AB 666 to gain open records access that we haven't had under the sealing law in California for 50 years.
One other comment. With all due respect, I practice in the same court as my colleague every day. And I'm not sure whether this massive amount of sealed cases are coming back and that they're not able to access, because that's just not the case. The point is, these are very minimal offenses that we're talking about that are getting sealed, if at all. There is a certain amount of discretion that's still left with the court to determine whether or not a record should be sealed. We use the word automatic, but it's not automatic. These children have to be successful on probation or whatever program they were put on to get a record seal. Another note, with respect to information that the district attorney gets, when a case is filed in juvenile delinquency court, if the child is detained, there's a detention summary report that's submitted to the district attorney, giving them information about mental health, giving them information about school, giving them information about family life. The probation department is tasked with every child that comes into their door to collect this information to pass on to the district attorney for them to make filing decisions on. So it's not a situation where they don't have any information whatsoever. That's just not the case. Information is also provided to the court after an investigation by the probation department with a social study report that drills down on information that they gather. The district attorney also has ready access to school records, which may contain psychosocial evaluations of the kid, but for mental health purposes. That's just a phone call away, and nothing seals that record. So I'm not sure what the horror is behind this particular bill. We've been sealing records in this state forever, and even in light of Prop 21. So I urge I urge this body to pass this bill.
Okay, Senator Stone, did you have a question?
Yes, thank you, Madam Chairwoman. I just heard, I thought the author say that the records being sealed would be law enforcement, district attorney, sheriffs, and that CPS and other orders would not be sealed. Is that what I heard?
What you heard, and let me again read from the bill, that what the bill is
Could you
requiring.
just tell us the page?
I'm sorry, I'm on page
Assembly
3
member.
of the bill, which is we're amending section 786 of the Welfare and Institutions Code. The very first provision is A. If a minor satisfactorily completes one, an informal program of supervision pursuant to section 654.2, 2, probation under section 725, or 3, a term of probation for any offense, the court shall order the petition dismissed, okay? The court shall order sealed, so we're talking about that petition. So that is that crime that's been committed. The court shall order sealed all records pertaining to that dismissed petition in the custody of the juvenile court and in the custody of law enforcement agencies, the probation department, and any other public agency having records pertaining to the case. So all other agencies are going to seal the record with respect to the petition dismissed. What the underlying public sealing or sealing of records law requires, and this has been in case for 50 years, is that we treat that offense as if it didn't happen. Now, all other records with respect to that juvenile in CPS, in dependency court, in whatever other agency that juvenile has touched, those records are unaffected by this bill because these are the records having to do with that case. Because if there's any thought that this is going to reach beyond the case and seal all those other records where that child has touched any other public agency, I just don't understand how one could come to that conclusion.
Well, I'd like to hear from the district attorney representative because I kind of see it her way, but I'd like her to codify that for me. Thank you, Madam Chair, if possible. I'd like her to respond.
Thank you. Thank you. I appreciate that opportunity. The language is quite open to that interpretation. And I am in the same courtroom as my colleague here from the Public Defender's Office here in Sacramento County. And I can tell you that different judges who sit down the hallway from one another in our courthouse, in the Juvenile Court of Sacramento County, interpret the language in the statute differently. And we are getting different rulings out of the statute that's on the books, 786, as we sit here today. And some of the judges in the courtroom are interpreting the statute on the books differently and are sealing district attorney files, probation files, California Department of Justice files, as we sit here today. So this proposed legislation is expanding that language. And to say that it wouldn't include child welfare as a public agency is just simply not the case, because our judges, some of the judges in our courthouse are going in that direction. So the petition, the language that's in AB 666, the petition that is at issue, we have crossover youth from dependency and delinquency in our courthouse left and right, senators. These are children who cross over, who are dependents and are now entering our delinquency system. Our children who are commercially sexually exploited youth are quite often dependent children who are now engaging in delinquent? No, and I'm so glad you brought that up, because when you say these are non-serious offenses, that's not the case. Lewd acts on a children that are non-forcible, which could be sodomy, rape with the assault with intent to commit rape, those are non-707 offenses. Those are all being sealed as we speak. Those don't fall under Welfare and Institutions Code Section 707B. Those are all being sealed right now. Under AB 666, those are all going to be sealed. So those children with those records that are being sealed, those children can be placed by child welfare into a group home and nobody would know because the records are sealed. That could very well happen.
Well, I think from the courts, most appropriately, again, this does not apply to the serious offenses, and to presume that the rest of the cases of that.
What about rape or sodomy?
Your Honor, rapists and sodomites are not having their records sealed in Sacramento County. I can attest to that. And I'd ask.
We have a Sacramento County problem. Either they're being sealed in Sacramento County or
Not
they're
being
not
sealed anywhere in California that I know
Lewd
of.
act on a child.
No,
excuse me, one at a time.
Thank you, Madam Chairman. Children that are charged with rape are not having their records sealed. I can attest to that. And if there's one that my colleague can give me, I'd appreciate it. But they're just not getting those records sealed under 786. I'm not sure what provision that they're being sealed under, but they're not happening. With respect to the CPS and child welfare question, though, a lot of our kids are, not a lot, we have quite a few kids that are crossover youth. We have several kids that are in dual jurisdiction or potentially dual jurisdiction status between delinquency and dependency. If a case is resolved in juvenile court and for a criminal act, and the child is put in the child welfare system while pending a potential probation period in the delinquency system, if that child is successful and that record is sealed, that does not terminate or seal the record in the child welfare system, because the child is still under the jurisdiction of the child welfare system. The only part of that that is actually sealed when you're talking about these crossover youth is the delinquency aspect, because there's still a viable case under the child welfare system and there's still a viable case under CPS. They cannot, as a matter of law, seal that portion of the case because they still have jurisdiction of their case. I think things are getting kind of overly simplified, but this provision we're simply talking about, we're not talking about kids that commit lewd and lascivious conduct on other kids or anyone else for that matter. We're not talking about assault with intent to commit rape. We're not talking about kids that are charged with rape. We represent those children. If someone in my office is asking for record seals, they're clearly being denied. But the law, as it is being presented here, does not provide for that. It simply doesn't.
And let me provide a couple other points that, especially with respect to the inconsistency, what we're asking for in this bill is that there are rules of court established and forms established to provide consistency across California. And secondarily, in this bill, probation does have access to the sealed records in order to help provide placements so that they are able to make sure that they're not putting kids in a situation that would be harmful to them or others around them.
You tell me where that is in the bill, because in my reading of the bill, let me put it this way. My interest is that if you have a child that's coming back into the system, there be adequate information available to plan a treatment program. I always appreciate, I have to say this, I'm sorry, but I appreciate hearing from DAs that their only concern is to help with treatment programs, because the DAs Association so often opposes every criminal justice reform that we see. But if in fact the only goal here is to get an adequate and effective program treatment so that we do not have recidivism and we have a system that works, I think that that is needed by all the parties to a case. It looks to me, frankly, like on page 3 of the bill, line 12, a key here is how pertaining to the case is defined,
Yes.
right? And then, but you said that there were other.
And if you look on page 4,
Yeah.
line 32, which is F sub C, if a new petition has been filed against a minor for a felony offense by the probation department for a limited purpose of, or that they may be, what the reference is that it may be opens by the probation department for the limited purpose of identifying the minor's previous court-ordered programs or placements, and in the event solely to determine the individual's eligibility for suitability or suitability for remedial programs or services. So the bill does allow probation to open the records to make sure that the placements are appropriate. And again, what's being sealed are the records with respect to the case, the crime that was committed, not all the other records where that child has touched any other agency. Those are available. And so if that child does come back into the juvenile justice system, it will be a little bit more difficult because the prosecutor will have to go to CPS or the other agencies to find out the status. They're not going to be able to go back into that record because, again, we've told that child, and this has been true for a long time in California, that we will treat that once you've done all the probation, once you've satisfactorily completed all of the requirements that this bill does and in the underlying sealing laws, then we've told that child we're going to treat that offense as if it didn't happen. So those records with respect to that offense are sealed. All other aspects of that child's life then are still, that child will be treated as if that's the first offense, other than, in this case, probation going in and opening the records to make sure that it's an appropriate placement through their processes. So we've tried to make sure that we are allowing the system to work for the benefit of that child. That's absolutely the underlying goal.
I know that it's the goal. I'm just trying to figure out what the bill also says. And I guess my question is, why wouldn't you want to know what happened under a prior petition if you had a child that was being seen again?
Well, if it's a serious crime, absolutely, and those records are not being sealed. But if it's a minor crime, and again, the sealing laws, which have been in existence for a long period of time, we tell that child, if you satisfactorily complete all the steps we make you do, then we will treat that offense as if it didn't happen. So why would we want to then go back in, open up those records, and treat it as if it did happen?
Well, a reason that I can see would be to understand more of the circumstances. My own experience in local government is that a young person usually makes many mistakes before they're actually put in the system. And if, in fact, you had a child that received a variety of treatment on probation and successfully completed it and had their petition dismissed, but then was back before you again, it would be a pretty strong indication that whatever you did before didn't work, and therefore would be important to know what was tried before.
Right, but understand, that's existing law. That's the state of the law now.
Yeah.
And so we're not asking to change that aspect of the law. We're trying to provide some consistency and get rules of court in
You
there.
mean we're not asking to change the ability of the court to go in and see what was tried previously with that young person so they can get an alternative plan?
Well, those records are supposed to be being sealed now. That's what existing law is. That system's not working that well, and those records
And why isn't it
do show
working?
up.
Where do they show up? Who exposes them to whom?
Well,
Again,
They are not-
sociology
They
of
are
crime.
not sealed.
Okay.
Madam
Let's
Chairman,
just-
well, part of the reason you have confusion in the courts right now is over the interpretation of what's being sealed. You have 3 or 4 different existing law right now, 3 different record sealing types of provisions. You have the 781 provisions which seal the record years after the child has been terminated from probation. You have the record sealing under the Deferred Entry Judgment Program for first-time felons, for minor felonies. And then you now have 786. All 3 of them say something different. The Judicial Council has interpreted the record seal under the Deferred Entry of Deferred Entry of Judgment Program in a way that provides for sealing of all of the different agencies that have access to a particular offense. The provisions under 781 has a total record seal. 786 uses the same language from the 790 provisions for deferred entry of judgment. That's what's causing the confusion. It's because one court interprets it one way to have a limited record seal. Another court interprets it because it's the same language of having a more broader record seal. This bill needs to clean that up. We litigated this case all the way to the California Supreme Court from Sacramento County as to get a consistent interpretation of this particular law. I would assume that the Supreme Court is aware of this particular bill and chose not to take jurisdiction of the bill to allow this body to come to some consensus as to what this should happen. So that's kind of what's causing the confusion. With respect to what the court can see or cannot see, again, if these children are coming back on serious offenses, they're going to take a totally different tact in how they look at this child anyway. If they're coming back on another minor offense, and like the chairman pointed out, sometimes we don't always get it right the first time, but if they come back on another petty or minor offense, it'll be handled accordingly because there's going to be an investigation and recommendations in terms of what to do to fix the child this time. And the irony in this situation, and I'll conclude with this, and the irony in this situation is in juvenile court, we have a continuing file. And what typically happens, even if the case has been sealed, if the child comes back, they have the same court number. And that court number tells us something. If a child is coming back and he's 17 years old and he has a court number from 5 years ago, the message is he's been here 5 years ago. And if need be, and if it comes down to a situation where we're trying to determine suitability for a particular program, this bill provides a way to get to that information.
Thank you.
Yes, ma'am.
Thank you. The conversation's been very informative. The bill has another stop before it gets to the floor?
The bill goes to appropriations.
Okay. If there's any further clarification that needs to be done, because I don't think anyone is in disagreement. We've heard a lot of different opinions of how it may be read, but there's no disagreement as to the intent. And I just want to thank Assemblyman Stone for attending to these particulars for the work that we had done earlier on what became 786, but that it is indeed entirely consistent with the intent of the legislation that created 786. And your office have been very communicative with our office and concerned with making sure that the original intent is respected, and you've done that very, very well. And I move the bill.
Although, Madam Chair, it sounds like you have some additional concerns. If you'd like a little bit of time, I'm happy to continue to work with you and address your concerns on the bill.
I would like to hold the bill over for a week.
I'm happy to do that.
More about this. If we hold it over, I think it should come back for vote only, because I don't want to go through the whole discussion again. But there are, as a non-lawyer, but a person very concerned about how we get adequate responses so that we put our kids back on track. I would like to be able to talk with everybody more about the bill and understand how the system actually
Sure, I'm
works.
happy to do that. And that is my goal, is to give kids that opportunity to get back on track. Otherwise, we lose them.
Exactly. I think that is what we all want. Yeah. So.
Madam Chair,
Yeah.
for those reasons, I will retract the motion.
Oh, thank you, Senator Leno. And we'll have to fit in some additional discussions during the week, and I welcome other people to also go ahead and have any clarification and discussion they would like to have.
Sure.
Staff has suggested maybe we should do it in 2 weeks so that we actually can get it done in a thoughtful way.
Your
Is that-
committee, your schedule, that's
Thank
fine
you.
with me. Sure.
Thank you very much.
Thank
I
you.
appreciate it. Okay.